Hi guys. So I'm back again because yet another order has dropped on the Jones docket. I have already recorded the video for Judge Lyman's ruling on the Jones Works motion to dismiss Wayfarer's counterclaims. But I'm going to release this one, I think, first, and then release that one after. Because this is some good news, which I think we all could do with. It's quite comical in some places as well. So back in December, Stephanie Jones filed a request to amend her complaint, and she attached the proposed amended complaint, which I did a video on. And basically, she wanted to bring in more claims against Melissa Nathan, one of them being defamation. And is it tortious interference with business? I think that might be it. But she also wanted to add Jamie Heath as a defendant, and bring a claim under the Illinois Eavesdropping Act, because he recorded a phone call between the two of them. So I've got the order in front of me. He has denied that. The short bit is that he has said no, which is fantastic. I was just going to read the bit around his actual decision. Not read the background, the legal standard, and everything else we know at this point off by heart. But just the actual rationale for the decision. So try and make this a shorter video. Okay, so discussion. I've got a dog and Mia's in with me as well, so she's snoring. So apologies for that. Okay. So defendants argue that the Jones parties have failed to satisfy the good cause standard for amendment under Rule 16. They further argue that even if the Jones parties had good cause for their untimely amendment, the motion should be denied because they would suffer prejudice by having to reopen discovery and because amendment would be futile. Defendants argue that the Jones party's defamation claim is untimely and the tortious interference claim is duplicative of its defamation claim and fails for other reasons. They assert that the court does not have subject matter or personal jurisdiction with respect to the claim against Heath, which they also argue fails on its merits. The Jones parties have failed to show good cause for their late motion to add the defamation and tortious interference claims. Instead, the late addition of those claims is the product of undue delay and a lack of diligence. Such an addition would also cause undue prejudice to defendants, and the defamation claim in particular is futile. The Jones parties have good cause for the late motion to add the claim against Heath, but that claim is futile because the court lacks personal and subject matter jurisdiction, and because the Jones parties do not allege damages. Accordingly, the motion to amend is denied. 100% agree with this. So I wanted to go just into, I'm not going to read all the kind of the citations that they add in, but I'm just going to go around some of Lyman's rationale behind his decision on these two elements. Okay, so Jones parties have no good cause for the late amendment of the defamation claim and the addition of the tortious interference claim. Defendants argue that plaintiffs have not shown good cause for their failure to amend to add the tortious interference claim and defamation claim against Nathan within the time period permitted by the court's case management plan. The Jones parties filed this action on December 24, 2024, and the court's initial case management plan and scheduling order was entered in this case on February 3, 2025, the same day the court entered a case management plan and scheduling order in the related case, Lively v. Wayfarer. The court established on April 18, 2025, the court established an April 18, 2025 deadline to file a motion to amend or to join additional parties. Yet the Jones parties did not move to amend until December 8, 2025, which is just fucking ridiculous. Defendants argue that the Jones parties knew of the facts underlying their proposed defamation and tortious interference with prospective business relations claim from the inception of this case, but inexcusably delayed seeking leave to amend. The court agrees. The original complaint alleged that Abel and Nathan contrived to have the Business Insider publish a hostile article about Jones, which was intended to have Jones Works clients, including Baldoni and Wayfarer, end their relationship with Jones. It also alleged that Abel and Nathan worked in concert with persons identified in the complaint only as John Doe's 1 through 10 to publish the website www.stephaniejonesleaks.com and a second defamatory website posted in September 2024 named www.stephaniejoneslies.com. The complaint contained a claim for defamation in connection with the Jones websites as against John Doe 1 through 10. It alleged that the John Doe defendants created and published the websites and that they were defamatory, but it did not contain a claim for defamation against Nathan on the basis of that conduct, or a tortious interference claim against Nathan based on the Business Insider article. The Jones parties argue that they could not have filed a motion to amend by the April 18, 2025 deadline set by the court because documents relating to Nathan's involvement with the Business Insider article were not produced by Nathan until August 6, 2025, and evidence regarding Nathan's involvement in the website was not known to the Jones parties until the deposition of a former employee of Jones Works and Nathan on September 5, 2025. But the Jones parties have not demonstrated that they exercised any diligence prior to the April 18, 2025 deadline to identify the John Doe defendants or to substantiate their allegation that Nathan contrived to have the Business Insider article published. The court entered the initial case management plan and scheduling order in this case on February 3, 2025, and as of that date, the Jones parties could have served requests for production of documents and interrogatories consistent with this court's local rule 33.1. The court set a deadline for service of requests for production of documents and interrogatories of March 14, 2025. The Jones parties complained that Nathan did not produce documents regarding the Business Insider article and the website until August 2025. But the Jones parties did not request such documents in their original request for production of documents. The Jones parties served a request for production of documents on Nathan on March 6, 2025. That request listed 27 different categories of documents. The requests that touched on the claims contained in the proposed amendment are the following: all documents and communications pertaining to Jones Works LLC, all communications relating to any Jones Works LLC client, including regarding actually or potentially terminating their relationship with Jones Works LLC, all communications with any reporter, journalist, correspondent, author, documentary filmmaker, or other member of the press or media regarding Stephanie Jones or Jones Works LLC. They did not include any requests for information with respect to the Business Insider article. The Jones parties assert that Nathan artificially limited her productions, but they do not dispute that it was not until July 2025 when they served a second request for production of documents that they requested documents relating to the Business Insider article and the websites. The Jones parties identify no other factors that would excuse their failure to exercise diligence or to act within the deadline set by the court. They concede that they knew, in December 2024, that Nathan fed information to Business Insider. They do not explain why. If so, they could not have added the claim that they propose to add now, charging her with defamation and tortious interference. They knew the content of the Business Insider article and do not dispute that they would have known if it interfered with the Jones party's business relations. They need not have known that she was the ringleader and instigator or the date on which she started to work on the Business Insider article to plead a claim for tortious interference. Nor do the Jones parties persuasively explain why, if they had enough facts to allege that Nathan worked with the John Doe defendants to publish the website and knew the content of the website, they would have had to wait until July 2025 to request documents from Nathan regarding the website, or December 2025 to propose to add Nathan to the defamation claim in their complaint. The Jones parties argue that the court can consider whether even an untimely amendment should be permitted in the event of a lack of prejudice, but they failed to refute Nathan's argument that she would be prejudiced by the late amendment. It may be, as the Jones parties argue, that they have already completed discovery into the article and websites, and that the Wayfarer parties already deposed the Jones parties and others about the at-issue statements. But Nathan is sued individually, and at the time the depositions were taken, she would have had no reason to know that the Jones parties would seek damages from her in her personal capacity for tortious interference and defamation. It would be unfair to make her defend against the Jones parties' arguments after all fact discovery in this case has closed. In addition, as to the defamation claim against Nathan, the motion would be futile. The statute of limitations for defamation claims under New York law is 1 year. Okay. The limitations period begins accruing when the libelous material first was published, that is, displayed to a third party. Okay. Courts thus have dismissed claims as untimely when there is no evidence that the plaintiff has made efforts prior to the running of the statute of limitations to identify the defendant by name. The Jones parties assert that they have exercised due diligence to discover the identity of the Doe parties as well as the origination of the Business Insider article since the outset of this litigation in December 2024. However, as indicated above, it was not until July 15, 2025, that the Jones parties asked for documents and communications related to the websites. By that time, however, the statute of limitations for defamation had expired. The defamation claim related to the websites, as against Nathan, thus would be untimely. I completely agree with that. I think that's a really good ruling. Now we're going to look at his reasons for the Heath, adding Heath to as a defendant, why he was saying no. The Jones party's claims against Heath are futile for failure to plead personal jurisdiction or damages. The Jones party's proposed 10th cause of action alleges a violation of the Illinois eavesdropping statute against Heath. The Jones parties allege that on August 8, 2024, while Heath was in Illinois, he recorded a private telephone conversation with Jones without informing her that he was recording the conversation or obtaining her consent. Although the defendants do not dispute that Heath's recording was not produced until October 5th, 2025, here are numerous defects in this claim. One thing I will say about this, right, is because damages is a factor in this. Like, how has it damaged you? I'm not aware that it's even on the docket. Like, I'm not. It's been produced in discovery, but I'm not aware that it's been attached to any particular motion, like for it to be, on the docket, unsealed. I haven't heard it. I don't know anyone who has heard it. So I'm not sure if it's been shared, and if so, if not, how would that have damaged her reputation. Okay, so first, the court does not have subject matter jurisdiction over the claim. To have subject matter jurisdiction based on diversity of citizenship, the amount in controversy must exceed $75,000. Okay. The party invoking federal jurisdiction must establish to a reasonable probability that the amount in controversy exceeds $75,000. This burden is hardly onerous, for there is a rebuttal presumption in the face of the complaint, is a good faith representation of the actual money in controversy. In order to overcome this presumption, the party opposing jurisdiction must show to a legal certainty that the amount recoverable is below the jurisdictional threshold. The presumption is not met with respect to the Illinois law claim. The proposed amended claim contains no allegations as to damages. In its reply brief as to the present motion, the Jones parties do not directly address defendants' argument that there is no good faith basis on which to assert at least $75,000 in controversy. Instead, as to damages, they argue that the improper recording and use of that recording constitutes harm for which damages are recoverable under Illinois law and intertwines with the harm defendants caused that will be proven at trial. There is nothing in the complaint to suggest a good faith basis on which to believe it is worth at least $75,000. This is confirmed too by the Jones party's failure to argue as much in their responsive briefing. The only other argument that the Jones parties make to establish the court's jurisdiction over this matter is that the court has supplemental jurisdiction. But the Jones parties have read that statute only in part. Section 1367A of Title 28 provides that in any civil action of which the district courts have original jurisdiction, the district court shall have supplemental jurisdiction over all other claims that are so related to claim in the action within such original jurisdiction that they form part of the same case or controversy under Article 3 of the United States Constitution. The Jones parties failed to address or cite to the statute's important proviso. The court has supplemental jurisdiction except as provided in subsections B and C, or as expressly provided otherwise by federal statute. And subsection B provides that in any civil action of which the district courts have original jurisdiction founded solely on section 1332 of this title, the district courts shall not have supplemental jurisdiction under subsection A over claims by plaintiffs against persons made parties under Rule 14, 19, 20, or 24 of the Federal Rules of Civil Procedure, when exercising supplemental jurisdiction over such claims would be inconsistent with the jurisdictional requirements of section 1332. Section 1367B explicitly excludes supplemental jurisdiction over claims against defendants joined under Rule 20. Second, the court does not have personal jurisdiction over Heath. At the pleading stage, the plaintiff bears the burden of showing that the court has jurisdiction over the defendant. The court indisputably does not have general jurisdiction over Heath, who is alleged to reside in Los Angeles, California. There is no allegation that the Jones party's eavesdropping claim arises out of Heath's transactional business in New York State, or that Heath committed a tortious act within New York. Heath is alleged to have been in Illinois at the time. There is no allegation about Jones's location when the call was recorded. The Jones parties assert that the effects of Heath's conduct were felt in New York, where Jones works is headquartered, and where Jones conducted her business. But whether an injury occurred in New York for the purposes of Section 302A3 generally depends on a situs of injury test, which asks the court to locate the original event which caused the injury. The situs of injury is the location of the original event which caused the injury, not the location where the resultant damages are felt by the plaintiffs. There is no allegation that the situs of injury was New York. Ultimately, the Jones parties rely on the fact that the court has already held that it has personal jurisdiction over Heath in the related lively litigation. Curiously, the Jones parties cite to the court's opinion granting the motion of the Wallace parties to dismiss the claims against them for lack of personal jurisdiction. The court did not decide because it was not asked to decide whether it had personal jurisdiction over Heath on the claims in the lively case. More importantly, a party can subject himself to jurisdiction in one case without subjecting himself to jurisdiction in all other cases. It is black letter law that even within a single case, a plaintiff must establish the court's jurisdiction with respect to each claim asserted. Third, the Jones parties do not allege damages from Heath's alleged violation of the Illinois Eavesdropping Act. Civil remedies under the eavesdropping statute include 1. An injunction prohibiting further eavesdropping, 2. Actual damages, and 3. Punitive damages. Punitive damages are available only if the defendant acted with malice, violence, oppression, or wanton recklessness, or the act complained of partakes of a criminal or wanton nature. The Jones parties do not identify any actual damages they suffered from the alleged eavesdropping, nor do they allege facts that would establish entitlement to punitive damages. They also do not seek injunctive relief. Conclusion. The court need not reach the other arguments raised by the parties. The Jones party's motion to amend is denied. So, and just in case I get asked this, he does not say whether this is with or without prejudice, but he does not need to either. So, because the defamation claim against, or the claims against that Jones tried to bring against Melissa Nathan are statute barred now, so they're outside the statute of limitations. So Stephanie Jones cannot bring them anywhere. Can't try any other courts. They're out of time, and she has no good reason for that. And then with Heath, I think what he's saying is, look, you're free to take it somewhere else, but don't bring it here because I've got no now. There's no the New York court. He has got no jurisdiction over Heath personally, or the subject matter, i.e., the Illinois Eavesdropping Act. So, if Stephanie Jones wishes to take that cause of action to a different court, she is free to do that. Most likely Illinois. But that remains to be seen. So she cannot amend her complaint. And that is that. Okay, guys. I'm going to upload this one now, and then later on I will publish the video on the outcome of the motion to dismiss against Wayfarer. Thank you for listening as always, and if you can subscribe, like the video, leave me a little comment or hype if you've got any hypes left. If you enjoyed this, it all helps my channel. Thank you so much. Take care, guys.